Go on from this course, this is the introduction course, right? So if you decide you want to be a compliance officer, senior, all that kind of stuff, money laundering reporting officer, you want to make it like a career, then you can do the international qualifications. There are 2 international qualifications, and then you have to take the test from the States or whatever, England or whatever. And Mr. Pratt could help you if you want the contact information. But this is just an introductory course for Bahamian compliance people to get people accustomed to thinking about what are the obligations under Bahamas law. If you want to go higher than that, you could go to the international qualification. We'll probably end up running a course for people who want to do the international later on down. But this first one, we got so much requests by people who say, I've been hired as a compliance officer, but I never had no training. So this is like an introduction one. There's a lot of stuff online too if you get into it. If you read the first handout, which is the definition of money laundering in the Wikipedia encyclopedia, there are a lot of what's called links to information on money laundering. So if you're really into it, you could go and do research. Huh? Oh, yeah. It's you know, it's one of those areas that's growing very fast, and a lot of people are spending a lot of money on training for money laundering. So if you're into it, there's a lot of information on the internet. Just according to if it excites you. Yes, ma'am.
You say the international designation, is it more recognized in ACAMS or?
ACAMS is one, and then there's another ICI or something like that. There are 2 of them. I don't know which one is the better one. Different people, you know, they say according to what they have, which is the better. But I think the ACAMS covers more material, so it takes longer. And then the IC thing doesn't take quite so long. Like I said, it's according to, you know, some people have both. You know, it's according to how deep you want to get into it, like everything else, you know. What I can say, the compliance area is probably best paid in the banking sector. If you are a compliance officer in the banks, you can go all the way up to the top and you get well paid. But there are a lot of people like web shops and so on who have compliance officers, but like that's it. There's only, you know, there's not too much further to go up. So if you go and do all those qualifications, you probably will have to look for an organization where you could climb the ladder to make it worthwhile. And some of them will pay for your qualifications. You know, they'll pay the expenses if you're really interested. So it's up to you. Some people go even further. They end up doing a course in auditing to go along with the compliance. Yeah, you know.
You all right?
It's how deep you want to go. But it is a growing area. And people pay for compliance people because compliance people could say, you know, yes, you take on a new customer, or no, you can't take on it. So compliance people have a lot of power. And then don't let you have to go to court and testify. Whew, you gotta be good. And the lawyers start fooling with you.
When you can pay for mine?
Hi, morning, how you doing? All right, morning, so thank you.
Welcome.
You have the CFATF handout? No, you didn't get it last week? Checks and make sure you don't have it in there. Some people think that. No, you only have the first one. Okay, that's good.
Price make me do it. I know.
a policeman. Morning, morning, how you doing? All right. There's a police officer who I lectured to, and he ended up going to work in France for Interpol on the same money laundering and financial crime thing. I think he was over there for like 2-3 years. And then, of course, he came back, he got big promotion when he came back and stuff like that. So, you know, this it's international. Once you get these things, you can work anywhere. I don't think we got this. The hand up for this week. We didn't get this yet, right? I don't know what you got. You didn't get it? Now you treat me like a stepchild. Eh? You've been there so long and I ain't even say nothing. Morning, morning. You have the handout from this week, CF right here?
Yes.
Well, you took it when I wasn't looking. Huh?
I was in here.
Ah, tricky. Very tricky, yes, ma'am. Who we got after? Who we got after?
No, I just wanted to find out if the exam is going to be again.
At the end of the last class. If I let you go, you mightn't come back. I mightn't see you again. Huh? I gotta let you go from the last class. You might be in Miami shopping. You might be at the Disney World. I mightn't catch you. I gotta catch you before you go.
Oh, that's the class, like, holiday weekend.
No, Mr. Pratt say ain't no point trying to have no class on the holiday weekend because Bahamians don't come to class on holiday. They be traveling to Miami and Orlando and stuff like that. So there's this class next week, and then we skip a week, right? The holiday week. I think he just don't want to come open up. I think that's what it is. But anyhow, I'm making no. So you get a break to study for the last class, right?
So it'll be that break and then the other week will be the last class.
Will be the last class, right? The following week we'll do half the class with review, and then the second half will be the test. So you could ask questions or anything that's not clear, so before you do the test. I try to be fair, even though my wife is talking bad about me, but I try to be fair. Okay, I guess we could get started. How many people were not here last week? Okay, so you need to introduce yourselves because we said who we are, where we work, and whether we had any training in compliance before. So,
Okay, my name is Ashley Burrows. I work for the Defense Force as well as Army Money Transfer Financial. I've done a little bit of compliance and compliance training.
okay.
Morning, my name is Michelle Kahneman. I work with Fidelity Bank.
Where?
Fidelity.
Fidelity, okay.
I'm compliance analyst. I basically do it every day.
So you've had training before? Okay, good. Very good.
I work at Beth Vegas.
Where?
Beth Vegas.
Beth Vegas?
Las Vegas.
What's Beth? Oh, Beth Vegas. Beth Vegas. Okay. Okay. Go ahead. That's it? You're compliant, so what? You're not, you want to get into compliance? Ah, you're looking for the career. You want to take over? Ah, you're tricky. Like them politicians. All right, okay. So we'll do a little review for the people who just arrived, and then we'll continue. Just what you need. It ringing.
There you go.
Okay.
Good morning.
Morning. Freeport?
Yes,
Okay, you want to introduce yourself, who you are, where you work, if you've had compliance training before?
my name is Siobhan Lightborn. I work at the Grand Mountain Port Authority and know I've never had compliance training.
Okay, all right. You got the handouts?
Yes.
Okay, excellent, wonderful. All right, so, to reach me, khiggins001@gmail.com. That's the first thing. Second thing is to clarify, we're gonna have a class next week, all right? But the holiday weekend, we won't have a class. And then the following week, we'll have a class where we do a review, answer questions, and then the second half of the class, we'll do the test. So you'll have a holiday weekend to study, then you'll have a review for the first half, 1 hour, ask questions. If you don't have any questions, we could go straight into the test. If you have questions, I'll try to answer them, and then we'll have the test, okay? Because they say you must have a test for you to be certified. So that's the plan. And as I say, you can reach me if you have any issues or problems. All right. Last time we talked about, first of all, what is the history of money laundering? How did it start? And we said that it really started from combating drug trafficking. What the Americans came up with was, since the drug trafficking business was a cash-intensive business, not only would they go after the drugs themselves, but they would also go after the money. And so they developed this concept of persons who deal with the proceeds of drug trafficking. That became a crime. Anybody who in any way worked with, accepted, invested, concealed the proceeds of drug trafficking was considered to be committing another crime called money laundering. So that's how it started. And it was so successful that they decided to broaden it. So first of all, they moved from the proceeds of drug trafficking to the proceeds of any serious crime. So today we have what is called all crimes money laundering, which means any money from any kind of serious crime, if you deal with it, you're guilty of a crime yourself called money laundering. So that's how it started. Now, it can get tricky because those crimes, all crimes, seem straightforward, but it isn't. Because the first question is it a crime in the Bahamas? There are crimes in other countries that are not crimes in the Bahamas. The big one is tax evasion. If you owe taxes in the States and you don't pay them, you can be prosecuted and go to jail. In the Bahamas is a whole host of people I know owe property tax and don't pay. And they go to work, they go to church and all, and ain't nobody's bothering them. So there are things in the Bahamas that are not crimes. Right now, apart from tax evasion, one of the issues that they're fighting over is human trafficking. There are, in most countries, if you bring people in illegally and then you take them to another country, like the States, that's a crime. But there's an issue about whether it's a crime in the Bahamas, human trafficking. So for example, there's a whole host of people in Bimini who take people to the States, illegal immigrants, and the question is, money coming from what the immigrants pay them to go across to the States, if you deal with that, is that money laundering? Well, the question is it part of the all crimes? So is it a crime in the Bahamas? And then the other thing that always comes up is it a crime when, or was it a crime, I should say, W-A-S, was it a crime when the act was committed? Can you go backwards where people made their money before it was a crime from an action and then say, okay, we're going to prosecute the bank or the person who took the money because it's money laundering? where is the cutoff point? So there's that question as well. So they talk about what's called predicate. Predicate offenses. Predicate offenses are the offenses which are caught by the all crimes definition. So crimes in the Bahamas, yes, but the law now says even if it wasn't, hello, morning, come on in. Even if it was committed in another country and it's a crime in the Bahamas, you could be charged with money laundering if you deal with the proceeds. You didn't get the handout, right, for this week?
No, sir.
Okay. Thanks.
Thank you.
So the predicate offenses can change over time. Let's say that, to use you guys, today, y'all are licensed as web shops. So you're legitimate businesses. There's no reason anybody should look down on you because you're licensed by the government. You're regulated by the gaming board. But let's say money that was made 5, 10 years ago, before you had a license, when you were quote unquote illegal as a numbers operation, if you have savings from that time, if you have profits from that time, should those funds be considered the proceeds of a crime? So it can get complicated. Now the government might say, we're not going to get into that long argument. We're starting from when you were licensed and going forward, you're legitimate. We're not going backwards, we're not retrogressing. But the Americans might take a different view. An American bank might say, I'm sorry, but these funds were accumulated prior to your receiving a license. So it's not straightforward. It is tricky, and it changes over time. Okay. The handout for this week is the CFATF Mutual Evaluation of the Bahamas. Let me just give you a brief introduction. One of the challenges of this whole area of money laundering, as I think I mentioned last time, is that we in the Bahamas don't set the standards. And there are no different standards for the Bahamas from the rest of the world. So you can't say like Bahamians say, well, you know, that's our culture, that's the way we do things. You can't do that. There are international standards that are set by FATF. Okay, this is the Financial Action Task Force. Financial Action Task Force. They're headquartered in Paris, France. Okay, and they're made up of all the international countries, US, Canada, UK, France, Germany, all the big boys. And they set the international standards. And then they have a regional organization, Caribbean Financial Action Task Force. The Caribbean Financial Action Task Force deals with the countries in the Caribbean and Central America. It's headquartered in Trinidad. So it's international people who set the standards, not Bahamian people. That's number one. Number two is they come into your country and they do an evaluation of your laws, your law enforcement, and all of that, your practices. So again, you have foreign people coming in using international standards to judge how you're performing. In other words, you can't BS. It's either you meet the international standards or you don't. You can't say, well, in the Bahamas, we ain't accustomed doing it this way and that. No, that don't play. So what you find is every depends on the problems you have. They can come every 10 years or every 5 years, depending on the problems you have, to visit your country. But this one is an example of the mutual evaluation for the Bahamas. And why I like it is because at the beginning it gives you an overview of all of the Bahamian institutions involved in this area of financial services, regulation, guidelines, money laundering, terrorist financing, and it evaluates how the Bahamas is doing. So the first couple pages give you an overview of the whole system, so you can get an idea, because we don't really have a textbook on the Bahamas. Hey, is she gone again? She called you?
Yeah.
She missed me already? Sorry. Call him anytime you can't see my face, right? Anytime you don't see my face, call him. Because he don't really want nobody in Freeport to know me, you know what I mean? He's get jealous.
Okay.
All right. So we have international standards, and we have international institutions that come in and evaluate us on how we're doing. So you can't get around it. You can't say, well, you know, we'll have lower standards in the Bahamas, or we won't really get too serious about this in the Bahamas. That don't work. So this CFATF evaluation is a good introduction to the Bahamian system and the kind of evaluation that we have to go through on a regular basis. So have a look at it, read it, and so forth. There is a couple of sections on gaming. There's not a lot on gaming, but they're starting to look at gaming and say, okay, gaming is regulated by the gaming board, but maybe it should have the same guidelines as the money transfer business, that there should be a single set of standards. So like I said last class, even though you might not think you have as strict a regulatory regime today as the banks and other financial sector agencies and enterprises have, we are moving towards a single standard for everybody. And I don't think it's going to be long before you find that you have to be reporting to the FIU, the Financial Intelligence Unit, rather than to the gaming board, because what they're trying to do is consolidate all of these regulatory agencies so that you have one standard. They're talking about this new, not new building. The government bought a building on East Bay, which used to be the Union Bank of Switzerland, UBS. Hi, morning. UBS, and they're going to try and put all the compliance people and regulatory agencies for the government in that one building. So they're moving towards a single standard. You were here last week?
Yes, sir.
You have the handout for this week or no? No? CFATF? No? This one? No? Okay. She told me you already got one. Don't give you no more. It's your friends, boy, I tell you. Anyhow, so like I said, the CFATF, read it and make notes if you have any questions. Now, there have been some changes since the report was done. I won't mention which ones. You should, if you read it, you should be able to see right away some things that are different today than they were when the report was done. But again, it's like I say, it's growing and changing and evolving. So this is not a field where you just learn it once and you stop. I have two sons, and you know, they did medicine and stuff, and I tell them that you learn one thing. If the man have a cold, you give them an aspirin, and for the rest of your career, you use the same thing. Man come in with a cold, you give him an aspirin. But in this field, it's changing all the time. So you don't learn it once. You have to continue reading to keep up to date with what's going on. Plus, of course, people are coming up with new ways. They call it typologies, methodologies of getting around the rules. That's another reason you have to read and keep up. So it's an active field that's changing all the time. Any questions? No? Everybody understand everything? Boy, I know this can be a good exam, boy. Everybody can pass with 100%, boy. No questions. Very good. Okay. Now, when we think about crimes, we think about people, individuals. And of course, that's where it started. But where the law has developed is with regard to corporate criminal liability. Corporate criminal liability. Let me ask you, if I want to gamble, I could come into the web shop and open an account. So, but can I open an account in a company name? Suppose I have a company and I say I want to open an account in a company name. I can't open an account in a company name. No? Suppose I have a partnership. No? Suppose I have an association. You're saying that? You sure? It's in the guidelines? You have a manual? Don't look at him. You've been answering me all along. Now you turn and looking at him. You talk to me. Huh? You have a manual?
Yes.
Yeah? And the manual says you can't open an account in a corporate name or anything like that. Or you just never seen it.
It has to be in your name, personally.
Personal name. Okay. That's what the manual says. Or that's what they tell you.
That's what the manual says.
Okay, good. I'm glad it's clear in the manual. Because this is where we get into problems. Is when people start establishing companies to do business. Because it's a natural thing. If you're going into business, people say you should set up a company to protect yourself. And of course, being a company, you can hide the true ownership. So companies are used a lot in business, both for legitimate and illegitimate reasons to hide ownership. Okay. Corporate entity is one thing, and the other one is natural person. And it used to be thought that only people, natural people, could be guilty of a criminal offense. Because, as I said, I think last time, you have to have what is called intent. You have to have an intention to commit a crime. If you just have an accident, that's not a crime. What you want is to show the person intended to kill or the person intended to steal. Then you have what is called mens rea in Latin, which is the intent to commit a crime, and then you can hold the person responsible. But because companies are structured differently, the question was, how can a company intend to commit a crime? A company is made up of a lot of different people. So if one person intends to commit a crime, does that mean the whole company is going to try and commit a crime? Well, the law said originally, let me read it for you. I know you all are not lawyers. When I do this presentation for lawyers, they get into a lot of discussion about this. They like this kind of thing. In 1957, the rule was, a company may be likened to a human body. Some of the people are mere servants and agents who are nothing more than hands to do the work. Others are directors and managers who represent the directing mind and will of the company and control what it does. The state of mind of these is the state of mind of the company. So for you to get a company convicted of a crime originally, you would have to show that the board of directors of the company intended to commit a crime. Now, let me make sure that you all understand how a company is formed. When you form a company, you have the shareholders. Okay? They're the people who own the company. But you might have 1 million shareholders. So all of them can't run the company together. They have to elect a board of directors. Okay, the board of directors is responsible for running the company. They then hire the management. Let's call it senior management, right? This is the CEO, the managing director, the general manager, whatever you want to call them, the senior management. And then, of course, the senior management will hire middle management, supervisors, staff, and so on. But that is the structure of a company. So what the law was saying is, since these are the people who run the company, for you to show that this company was criminally liable, you have to show the board of directors intended to commit a crime. So it was very seldom you would find a company being guilty of a crime. And then, of course, the next problem is going to be, who goes to Fox Hill? Is it just the board of directors? Is it the senior management? Is it the staff who committed the crime physically? Who goes to Fox Hill? So then the law went on and said, okay, because of the pressures of so many problems with corporate entities getting involved in fraud and bribery and all these things, in 1972, the court said corporate liability attaches to persons who under the memorandum and articles or who as a result of the director's actions are entrusted with the exercise of the powers of the company or are granted discretion to act independently. In other words, the court said, yes, the board of directors is responsible for the company. Yes, they are the mind and management of the company. But if they delegate authority to a senior manager, and the senior manager intends to commit a crime, the company is still responsible. So it moved from the board of directors down to senior management. If you can show that a manager intended to commit a crime, the whole company could be held responsible. Excuse me. But again, like I keep saying with this area, it keeps growing and changing. So the next step was, in 1995, the Court of Appeal said it was no longer necessary to establish whether a particular employee was part of senior management or not. Any staff member could make the company guilty of a crime. So now we have a real problem. That means that some supervisor or some staff member who is building the new building I see on Cable Beach there on West Bay, that's Island Luck or something? I see a new building going up. So the manager there could do something, or a supervisor there could do something, and the whole Island Luck company could be held criminally liable. So now it started to get serious. If a junior employee could make the company liable for a criminal offense, now it was getting serious. So companies started sending out memorandum to the staff, sending out instructions to the staff. You should not do so and so. We are prohibiting our staff from getting involved in this, that, and the next thing. But again, the law changed. The law said in 1995, even in the case where a company has issued express instructions to all its staff members prohibiting certain actions, the company could still be held liable. Lord Nolan stated, liability can only be escaped by a completely effective preventative measure. Now that's nonsense. If you have a completely effective preventative measure, you'll never be in trouble. Because completely effective means that it stops it all the time. Excuse me. But what the court was saying is you need to come up with a system designed to prevent and identify when it occurs these problems. Let me get some water. I see I stand the clock. Excuse me. Okay. So it is from this decision, if you want to know the case was Ready Mixed Concrete, 1995, where the court said you must establish a compliance system. Ready Mixed Concrete, 1995. The House of Lords in England. This is where the compliance system started, because when the court said completely effective preventative measures, people say, well, okay, that means we need to have a system in place to prevent and, of course, to identify when it does occur, this problem. So you say, all right, fine. I understand that. Now we need to have in place for the company a system to make sure that there are rules and guidelines, okay, but we have to make sure that people follow the rules and guidelines. I got it. But the law didn't stop. See, the law keeps changing and pushing that responsibility harder and harder onto people because of the seriousness of this drug trafficking thing that started it all. We're going to talk about terrorism, which is taking it over the top. Because if you think the Americans were serious about drug trafficking, you should see what they are about terrorism. After they bombed 9/11, all of those Americans who lost their lives, so they ain't playing when it comes to terrorism. So the law has changed even further. In the past, when people served as directors of a company, they had what was called indemnification. What is indemnification? To protect them. Anybody know that word? Indemnification means if you get into a problem, the company will pay for your lawyer and legal fees. Hi, morning, come on in. You were here last week? No. No? Okay. You have your folder? They gave you a folder?
No.
This the man, bang him on his head, right?
No problem.
All right. Where's the sheet? Everybody's name is on the sheet? All right. Question? Or you need a sheet? Okay. Right. If a company got into problems, like let's say an employee was charged with money laundering and then they charged the company, the board of directors had an agreement with the company that the company would pay their legal fees. And even if they were found guilty and fined, the company would pay the fine on their behalf. So many people say, well, I don't really have to worry about it because the company will protect me because of this indemnification. And in fact, there are insurance policies. Hey, hold on. Listen, I don't want to see myself on ZNS, you know. Right. Plugging in and unplugging. I hope you all know what y'all doing. Next thing my wife says, oh, that's where you used to be in the morning. Yeah, there's insurance called professional indemnity insurance that companies used to take out so that if a director is charged, if the company gets into problems, the insurance company will pay all the legal fees. But the law says, excuse me, a company is prohibited from paying fines, judgments, settlements, and legal expenses except where directors have acted in good faith and had no reasonable cause to believe their conduct was unlawful. So in other words, they're saying If you can show me that the directors intended to commit a crime, they are not protected. They're not protected by indemnification. It has to be they did not know what was going on and some junior employee got the company in trouble. Let me give you an example. I was once upon a time, many years ago, the branch manager for a bank, Canadian bank. I was the manager. I drove a Volkswagen. We had a teller who drove a Mercedes. I'm the manager now. I got a Volkswagen. She's a teller. She got a Mercedes. Her thing is, her boyfriend buy it for her. Nothing wrong with that. They have some men who's stupid. You know, it's nothing wrong with that. You get a good man, you get a good man. But what was she doing for her boyfriend to make him buy her Mercedes? Well, of course, we know that part. We ain't worrying about that part. That's normal. But she was also cleaning some money for him. She was putting money through cash, through an account that really she should not have been accepting as a deposit from the public because it was too much. It was over the limit. So she is committing a crime. Now, I as the manager, if we find out she's committing a crime, fire her, no problem. Don't bother me none. I sleep like a baby. She commit the crime, she go. But what happens now if the company is charged with a crime and me, the manager, is charged with a crime? Then it starts to get very complicated. And since the indemnification is not going to protect me, I'm going to get very serious now about watching my staff. Whereas before it didn't worry me, now I have to watch them because I won't be protected with the indemnification if charges come up unless I can show that I didn't even know what was going on. So you say, all right, well, I mean, that seems fair. If you knew what was going on and you didn't do anything about it, then you should be liable. But if you didn't know what was going on, then you should be protected. That's fair. Excuse me. But again, life is not easy. They came up with this thing called vicarious liability. Actions of employees result in liability for the company and or directors and or senior management, regardless of their knowledge of the action. So it don't matter anymore whether you knew about it or whether you were aware. The position is once you are a director, once you are a senior manager of the company, you are responsible. The only way you can protect yourself is to show that you took every possible action to enforce the compliance system. You see how the law is changing? The law started off with crimes to say you cannot just make a person responsible for a crime unless you could show they intended to do it. And now it's gone to the point where you could be responsible for a crime even though you didn't even know about it. That's how serious they've gotten. Anything done or omitted, now this is another thing. Crime was you had to do something. You had to kill somebody. But now it is anything you've done or omitted. What they mean by omitted. If you knew this was money from a crime, proceeds of a crime, and you omitted to file a report, you see what I mean? You don't even have to do anything. Even if you don't do nothing, you could be guilty of a crime. or omitted by a person as the employee of another shall be treated as done or omitted by the employee and employer, that's you and the company, whether or not it was done with the employer's knowledge or approval. I mean, this is getting ridiculous. Somebody does something who happens to work in the same office with me. I don't know anything about it, but because I'm a manager or a supervisor, all of a sudden I'm responsible. Even though I didn't know anything about it. I mightn't like the person, but I'm still responsible. Where a body corporate, that means a corporation, a company, is convicted of an offense, where the company is guilty, every director and every officer concerned in the management of the body corporate shall be guilty where it is proved that the act or omission constituting the offense took place with the person's knowledge, authority, permission, or consent. So the law is starting to get more reasonable. They're saying, all right, if you knew about it, you're guilty. If you consented to it, if you knew about it and didn't say anything, you have to have some connection. So that's a little bit more reasonable. But they had gone to the point where you didn't even have to know about it and you could be guilty. That is the extent of this money laundering crime. It is so broad that the only defense is to show that you had a system in place, that you enforced the system, and of course, like we said last time, the best defense is to disclose it to somebody. Tell somebody. Once you have told somebody, the responsibility leaves you and goes to the person you told. When I say told, I mean the right person, the money laundering reporting officer or compliance officer, and told meaning in writing. So you have evidence that you told. The defense, that you took steps to reasonably prevent the employee from doing or omitting to do. In other words, if you know about the employee, you have to do something to stop it. Or if the employee doing the thing from doing or omitting to do as an employee or agent, as the case may be, of that person, thing of that description. Things of that description. Okay, so the defense is, if you're an employee of the organization, if you knew about it, that you tried to prevent it, or that you reported it, or if you didn't know about it, that you were actively, as a supervisor or manager, trying to enforce a compliance system. Because the court is going to say, did you have a manual? Did you do training? Did you keep proper records, and so on? And then if you can say that, yes, I've met these requirements, they will say, well, okay, you have done everything within your power to protect the organization and so on. So again, the idea I'm trying to get across is this is a broad area, and the law takes the position, show me why you're not guilty. It doesn't say you're guilty until you prove innocent. In money laundering, it says, show me why you shouldn't be guilty. Show me what you have done to protect the organization. Show me what you have done to prevent this crime. Then we could talk. So it's that kind of environment that you're in. It's very tricky. Any questions? Still no questions? Everybody understands everything. Okay, we can see. No problem. No problem.
I have a question.
Ah, great.
So what if you show all those things,
Right.
but then the crime still happened, then what?
No, but that's not, crimes are going to happen. You can't stop crimes from happening. What you want to do is make sure you don't go to Fox Hill. So you want to show that you have done your part. You have trained your staff. You have given them a manual. You have given them all the reporting forms, etc., etc., etc. Then you're okay. And that you didn't know about it and not report it, or that you didn't know about it and try to prevent it.
So in that case, if the company and the compliance officers did their job
Right.
by holding,
Training, manual,
manuals.
reporting, etc.
So if the person, the individual, still goes ahead and commits some
Right.
kind of fraudulent activity, then they get fined.
They're the ones who get,
Who take the responsibility.
first of all, fired, secondly, fined or go to jail or whatever. There still could be a fine against the company. Because even though you have done your job, they might say that the company hasn't put in place an effective system, even though you're doing your job. But the point is, you're protected. My first responsibility is make sure I don't go to Fox Hill. I don't care if the rich man at the top who own the company go to Fox Hill. That's his business. But I'm making sure I don't go to Fox Hill. So that is it. And why that is important is because you have different branches, right? So you might have one branch of the company that's following the rules, training their staff, doing everything they're supposed to, and you might have another branch where the manager ain't checking. So the company will still be held responsible if they find that it doesn't have a comprehensive system. But you at least are protected because you did what you're supposed to. That's why I said I have never seen another crime like this. And this came out of, they say the most dangerous thing in the world is other people's money. And this is where the problem is, other people's money. Money passing through, you don't know where it's coming from, you don't know why it's coming. How do you protect yourself? Why did the PLP lose like they lost? Tell me. When you read in the paper about Mr. what do you name? The Minister of Labor. The man get $94,000 in US dollars in his account. Yeah, how you feel about that? You start to get angry. Then you get another fella, millionaire, saying, man, I need a couple of dollars to help pay my father's bills and so. You start to get mad. Other people's money. It's dangerous. And that is the problem. Okay.
Oh, Mr. Higgins, these dates that you're calling off in your handout, in
Uh-huh.
your personal sheet, should we be taking records of these, or are they in this handout as well?
No, they're not in this.
So,
You want me to give them to you again?
yeah, are those important?
This is more important for lawyers because this is how the law has evolved. I'm just giving you an idea. I wouldn't ask you what is the name of the case when this happened and they brought. I wouldn't do that because you're not lawyers. But when I do it for lawyers, they actually follow the precedents how the law has expanded and which decisions were made by which courts. Because some courts apply to the Bahamas, the rules, and some courts don't apply to the Bahamas. So it gets more technical when I do it for lawyers. But no, this is just to give you an idea of how the law is changing and why you need to pay attention. Because what's the law today mightn't be the law next year. That's all I'm saying. You all have a legal officer in your company? Right. So it's their responsibility to let you know if an act is amended or if there's a new decision by the court that affects compliance. That's their job to let you know. You can't be everything. Okay. I want to go on to some more of these legal things. Under our laws, the courts have certain authorities. One, to gather information. Two, to freeze assets. Third, to charge assets. And four, to confiscate assets. Okay, first thing. When the government, the law enforcement authorities are conducting an investigation, they may need information from a financial institution. They may need information on deposits or withdrawals or payments or money transfers, so on, so forth and so on. The court can issue two kinds of orders. The Supreme Court can issue what's called a production order, which says you must produce the records for this particular client of yours going back 6 months or a year or whatever it is. And if you get an order like that from the court, then you have to provide the police officer or whoever delivers the order with that information. A magistrate can issue a search warrant. Now you have to be careful. We used to think in the old days a search warrant meant going into somebody's house or somebody's car or somebody's boat, a premises. But under the law, a bank account is a premises. Under the law today, a company is a premises. Under the law today, a trust is a premises. So you can get a search warrant to search your accounts. We never had this before, but again, because the law is evolving and expanding, now you can have a search warrant for an account. Now suppose that they identify assets belonging to somebody who is under investigation for drug trafficking, or for armed robbery, or for fraud. The first thing they want to do is freeze the assets. They don't want the money moving because, of course, if people know that the government is coming after them, they're going to transfer the money elsewhere. They're going to try and hide it. So you can get a freezing order, okay? It's called a restraint order. A restraint order from the courts, which says that you must not allow that money to be moved, withdrawn, transferred. A restraint order. Then the government might say, all right, we have the assets, we have it frozen, and we are now going to take this person to court, and we're going to collect from them the legal fees that result from this whole case. We want to make sure we could get that money back from them. So there is something called a charging order, which allows the government to take the costs of their legal action from the accused. All right? And then if the person is convicted, they're found guilty, then of course they forfeit the assets. Right? So first they gather information, then they freeze the assets so they can't move, then they charge the assets to cover the cost of the investigation and the legal action. Morning, morning. And then they can confiscate the assets. Everybody with me? Okay. Now, I have had cases where on a Friday afternoon, it always seems to be a Friday afternoon, with a bank or a trust company, when the managers have left half day to go play golf or go out in their boats or whatever, the police show up with a production order. The only people in the office are the cleaning lady, the janitor, and the messenger. And because of how people are intimidated by police, and because of how people say, well, the janitor and them, they don't need to be trained in these things. So when the police show up with the paper, with the stamp and the seal and all it looking so serious and professional, the man says, I need to have the files on Mr. Higgins, so and so and so. And the lady said, well, I don't know nothing about it, but see the filing cabinet over there, you could go look and take what you want. Then you have a serious, serious problem. So you need to ensure that as part of your procedure, your manual, you have in place a procedure for your staff to follow when they are presented with a court order. What must they do? Because most of us, we're not lawyers. We're intimidated by lawyers and police and documents and so on. So you need to have very clear, when you receive a court order, you refer it immediately to the legal counsel. Do not release any documentation until the legal counsel has approved it. Something. I mean, even if your manual say when you receive a court order, kneel down and pray. Something. You got to have something. Because this is the problem. Now, another point. Suppose that the court order says, we want a production order for the account of Kevin Higgins. And suppose I have an account for Kevin Higgins. I have an account for Kevin and Stephanie Higgins. And I have an account for Kevin in trust for Jonathan Higgins, my son. Which file do you give them? Only, no more. Only that one. Because if the documents say Kevin Higgins, you give him Kevin Higgins. You don't give him my sweetheart file and all the rest of them. And that's one of the problems. People see Kevin Higgins and they just give everything with Kevin Higgins. No. One specific reference, that's what you provide. If they want Kevin Higgins and any other accounts jointly or severally held, they'll say that. But if they only say Kevin Higgins, that's all you provide. Because if you provide what they have not asked for, then the customer can sue you. Because the customer will say, you're in breach of his privacy because they didn't ask for that, and you, out of your goodness, kindness, ignorance, whatever, just give them the whole thing. So again, I emphasize, you need to have a procedure in place to handle how you deal with the receipt of court orders. It's a tricky area. It's an area where people get intimidated and frightened. And so you need to be able to say, well, officer, I understand what you're saying, but see it here in the manual. This is what I have to do. I have to advise the legal counsel. I cannot release it. And then he himself will say, well, okay, you ain't being difficult for being difficult. You have a procedure in place. But if you don't have a procedure in place, if you cannot document it and show him, he's going to say, well, you're obstructing justice. I could carry you in too. So for your own protection, you need to have in place that kind of procedure. Everything has to do with thinking ahead and planning ahead to protect your staff. Because this ain't nothing to play with. Any questions? No? Okay. All right. So you get these production orders. Production order says, I want identification information. I want ID information on K. Higgins and Company Limited. Now, everybody knows how to get ID information on K. Higgins. You want a passport, you want a driver's license. We said you could get a voter's card, right? Me personally, I think national insurance card is critical for me as an identification because it says this person has been working before, they're part of the system. Not everybody travels to Miami and has a passport. Not everybody drives a car and has a driver's license. But if you don't have an NIB card, something wrong with you because it means you never work in your life. So I don't want nothing to do with you, no how. Because you can't have no legitimate money because you never work. But let's say it's a company. What is the identification documentation you would ask for from a company? A company is a legal entity that is artificially created under the law. It isn't born like at Princess Margaret Hospital. Although they talk about a birth certificate for a company. But what is that?
Over here, business license.
Say?
Over here.
Over here?
Oh, business license.
A business license. Yeah, but you got to be somebody to get a license. So first you got to be born. Then you got to apply for a license. So what is the born in part for a company? That's what I'm trying to get at. You understand? You're born, and then you go to school and get an ID, and then you get a national insurance, and then you get a passport. But you got to be born first. So a company has to be born, and then it can go and apply for a business license. So what is the documentation on the being born part for a company?
Incorporation. Incorporation.
Right. Can I rub this hair out? Okay. For companies, the birth certificate for a company that tells you when it was formed, when it was born, and who born it, that means who owns it, who are the directors and officers and all that, is the certificate of incorporation. So anytime you have anything to do with a company, opening any kind of relationship, a bank account, charge account, credit account, loan, anything like that, the first thing you want is the certificate of incorporation, because that's the ID for a company.
What if it's a small company? Small companies don't usually have certificate of incorporation.
No. See, this is the tricky part. You're using companies to mean business. Small businesses may not have, but a company is a legal entity that is incorporated. So if you say small businesses don't have, we could talk about that. But once you say you are a company, you gotta have a certificate of incorporation. It's like my thing. If you say you're a man, you gotta take care of your obligations. Otherwise, you ain't a man. So if you're a company, you gotta have a certificate. Now you could be a business. There are a lot of businesses that are not companies. Let's talk about that because this is important. See, when me and you sitting down drinking and talking, having a good time, we could say anything. But when they put you in front of the magistrate in court, you got to talk like you know what you're talking about. Otherwise, they can say, well, this employee obviously didn't even realize what they were doing. Let me make an example of her. You got to talk like you know your business. So let's talk about business. Sole proprietorship. Partnership. Corporation. Association. Okay. If you decide tomorrow, you're out of this compliance business, after doing this class with Mr. Higgins, you can't take no more of this nonsense, you want a simple life, I'm going to open a beauty salon. Suppose you decide that, right? So you go down, you apply for your business license, and you open your beauty salon, and you're doing hair and nails and facials and all, and every time I pass, you laugh at me and say, look at that man, I'm so happy I ain't that no more. Then you have a sole proprietorship. You have a business which is in your name and which is the same as you. So the business's bills are your bills. Whatever the business owes, it's on you. Now, the thing that's tricky is you don't have to call your business Kevin Higgins, even though it's you. You could be Kevin Higgins trading as Pretty Girl Salon. So people think Pretty Girl Salon means you have a company, but you don't. You're just trading as. You're using that name. So you can't tell by a business whether it's incorporated just by the name. The next one is partnership. You set up your salon, but you don't have enough money to buy all the equipment. So you come to me and you say, Mr. Higgins, you know, I always liked you. You are a good lecturer and whatnot, but I can't take this nonsense no more with this money laundering. I'm going into a business, and I'm looking for people who will invest with me and be my partner. And I look at you and I say, you want me to be your partner? You know what you're dealing with? And you say, yeah, I know what I deal with. And I say, all right, fine, how much you need? You say, well, I need $5,000. I say, all right, fine, bam, 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 $5,000. Start your business. I am a partner. So we have an agreement to work together. A partnership is two or more people who agree to do business together. Now, we might split the money half-half. You might take 60%, I take 40%. All of that is in the agreement. But the point is, the two of us are responsible for the business. So if the business gets into trouble, the two of us individually can go to jail. Because the business is the two of us. It's not just you, it's you and me. But still, it's the individuals, the natural people, who go to jail. So to protect themselves, people develop corporations, incorporated entities, companies. Now, this is where you set up a separate legal entity, different from yourself, to do business. And there are rules you have to follow. You have to form the company, you have to have the certificate of incorporation, it has to be registered with the registrar of companies, the things you have to do, and so on and so on. So that if the company gets into problems, that's different from you personally. The company's bills are different from your personal bills. It's a separate legal entity. That's a way to protect yourself. And that's how big people do business. I don't want you coming after my house in Lifer Key. I don't want you coming after my big boat. Let the business go and operate. If it makes money, it makes money. If it loses money, it loses money. But it's got nothing to do with me. Whatever money I put in at the beginning, that's it. I don't want you to come back and ask me for nothing else. So that's the corporate entity. And there are different kinds of companies. You have ordinary companies that do business in the Bahamas. You have international business companies, IBCs, that are set up in the Bahamas but to do business outside of the Bahamas. You have limited duration companies, LDCs, which are companies set up for a specific time period, 5 years or 10 years. You don't have to set up a company to last forever, although companies can last forever. If you keep paying the fees, they'll last forever. But you can set it up just for 10 years to do a particular project. Hold on, this report seems to be gone. Hey, let's look. Freeport gone again. Freeport always was a problem. I don't know, Freeport, they have their own way of doing things. It's better. I can send you a ticket next Saturday so you can come over, okay? All right.
Please do.
All right. Right, so you have different kinds of companies that are set up for different purposes, but all of them are separate from their owners. Okay? And then associations. People wanted, let me give you a classic example. I decide I'm tired teaching for the Institute of Financial Services because they don't pay me no money. I'm going to start a church. I'm going to start preaching. Right? And I'm going to gather together the sisters and we're going to build a church and raise money, cookouts and so forth, and get tithing and everything, and we build this church. And I put the land and the church in my personal name. Is that right? No. But at the same time, I don't want to put it in a company name because it's not a business company. So I decide, okay, we will form an association. All of the members of the congregation will come together to form an association. So you have sports associations, charitable associations, those kind of things, non-profit associations. So all of these are different structures you can have, I call it business, but for activities under the law. And each one of them is different. That's why when you say company just now, I know you mean business, but a company is a corporation, very specific. A incorporated entity set up under the law to do business for profit. Okay? Now, we were saying certificate of incorporation. Who watching the time? Who's the timekeeper? You? And you come late? And you's the timekeeper? Jesus Christ, man. I can't trust you at all. Oh, Lordy. Right. You got a watch? I just check it. I just make it sure. All right. The other thing you should always ask for from a company is the memorandum and articles of association. This is the thick document that sets up the rules of the company. Okay? The memorandum and articles of association. The memorandum tells you how the company can operate in business in the outside world, and the articles tell you the rules for the company to operate internally. Who can be an officer, who can be president, how many signatures you should have when you're signing official documents, all the internal rules. So those two documents really are very important anytime you're dealing with a company. Whether it's opening up, yes?
Okay, so alongside the certificate of incorporation, the certificate of incumbency can be used as well.
Certificate of incumbency? Now, what do you mean by a certificate of incumbency?
When you're saying to get the full and correct legal name of all persons associated with the account as signing authority, can the certificate of incumbency also answer that question?
I don't think so. Incumbency has to do with if you give the company's assets to somebody as security for a loan. That means like a mortgage or something. That's a different thing. But when it comes to signing powers, SIGN, signing authorities, I ask for a resolution from the board of directors. See, the board of directors can say, Mr. Higgins can sign on this account by himself. Or they can say, Mr. Higgins and Ms. So-and-so must sign together. Or they can say, Mr. Higgins can sign with three or any of the three other persons. They can make the rules about signing authority. But it has to be in a resolution from the board of directors. Because that can change and it can be different for different accounts. But the idea I'm trying to get across to you is companies are more complicated than people. And anytime you do business with a company, you have to be careful. Because you may not know who are the real owners of the company. And the company may be used to disguise the true beneficial ownership. So you may open an account for a company, you may be doing business in the company's name, and you may not even know who owns the company. And so when the court comes to you and says, this company we believe is involved in money laundering, give us the ID with the production order. Give us the identification documentation. And you say, well, I don't really have anything. No, you got to have the certificate of incorporation, the memorandum and articles of association, and who can sign on the account. But it's not even that. It's more complicated than that. Suppose the certificate of incorporation was for 1999, and we are now in the year 2017. The court is going to say, but this is a certificate from 1999. How do you know this company is still operating? How do you know this company ain't dead? So how do you know it ain't buried in Woodlawn? Then you have to ask for a certificate. Aha! You smart and you look, you know. Certificate of good standing. That tells you the company is still operating, and this is done annually. So you get the most recent one for 2016. Otherwise, you got problems. You don't know if this is a dead company or a live company from 1999.
Oh, Mr. Higgins, you said the memorandum is for external.
Yeah, the company's relationships with external, and the articles is for
internal?
inside. Who can vote, who can be an officer, that kind of
So
thing.
those
The
are
rules
fees
inside.
and the standard operating procedures.
Right.
Something.
Right. Articles internal, memorandum external. Like for example, if you go, the company goes to borrow money, the memorandum will say it can only borrow X amount, or the loan has to be approved by the board, or what, those kind of things. Right. This is not an area for lazy people, this money laundering business. This is a serious area. So when you go home tonight, you puff out your chest and say, I'm studying money laundering. Let them know that you're a serious student, that I'm a professional compliance officer, and I want respect. You let them know when you go home. You're not taking no nonsense no more. Okay? Because this ain't nothing to play with. You let them know. So, IDs for companies. Question? All right.
Okay, so all of these documents that you have here, I'm gonna be saying exactly what the beneficial owner is. So where will we get that?
Okay, let's see if we can explain for those who are not aware. We live in a system of English common law. Okay, there's two kinds of systems in the world. There's English common law, and there's the civil code of Europe. Okay, so you have England always is different because they're island off on their own. They always have their own thing, and then France and Germany and Holland and Denmark, all those countries, they tend to have the same kind of thing. Now, under our English common law system, you can have a legal owner and you can have a beneficial owner. The legal owner is the owner of record, the name on the paper, the owner of record. The beneficial owner is the true owner, the person who benefits from the assets. And this is tricky. This is tricky. Because really and truly, under civil code, there's only one owner. It's only the British who are so tricky that you could have two owners. And this is where the whole trust thing comes from, where I say I own it in trust for somebody else. I am the legal owner, but the true owner is somebody else. And that's where we get problems. I mean, that's another area we get problems. It's because we want to know who is the beneficial owner. Is the beneficial owner the criminal committer? And the problem is there is no single document that has to record the name of the beneficial owner. So the only thing you can do is ask the person opening their account, are you the beneficial owner? And they say yes or no, and there's nothing more you can do. There's nothing else you can do. Now, of course, if I see a fellow walk in with a dirty tear-up pair of jeans and a flip-flops, and he get on a, what do you call them, singlet, and he want to open an account, and I ask him, how much is the deposit? And he say $10,000. I can burst out laughing, because I know he can't have no $10,000. And I say, well, but are you the real owner of this? And he say, yeah, it's me, it's my money. I say, how I get it? He said, well, I got it, won it last night from one of the web shops. And I said, well, where's the check? He said, no, well, I cashed it already. I got it in cash now. But I have to say, well, I'm sorry, my friend, but I can't accept that.
Because he have on a singlet.
Because you have a flip-flop and a tear-up jeans. If you get $10,000, at least you could buy a decent pair of jeans and a pair of shoes. Jesus Christ, man. You come in to open an account with $10,000 and you don't even stop to brush your teeth and get a little haircut and look good? Something wrong. I'm prejudiced like that. I like my people looking good. You would accept that? You would open your account for him?
So even if he wanted cash check and dress himself up and to make it work, would you still take it?
No, well, if he dressed himself up and he looked halfway decent, then I might start to believe it. But they already tell me that anything over how much you get a check? How much?
10.
Over 10, right. Over 5 you get a check. So why is he bringing me cash and tell me you win it at a web shop? Why isn't it the check with the web shop name on it? But I'm just saying.
Yeah, it's hard to track winnings, and so we don't accept it. Like us, the compliance people, like, no, we can't.
That's what I'm saying. When I was young, I was working for the central bank. I used to travel on business. And my thing was, if I got to travel on a plane for 4 or 5 hours, I want to be comfortable. So I put on my old jeans, my flip-flop, a t-shirt and so on. And a friend of mine says, when you're traveling on business, you're already black. You already get a problem with American customs. Who you is traveling up and down on, you say business, you say you're an economist, work for the center, and you wearing flip-flops. So I start to realize it's not me, The problem is not me. The problem is how people see me. This is the problem. It's perception. So I started traveling with jacket and shoes. And all of a sudden people start saying, Mr. Higgins, would you like to move up to the business class? I said, yes, no problem. He said, come and sit in the business class, Mr. Higgins. Because I get on a jacket and a shoe, and I say, these people are stupid, eh? That's the same old me. But perception is very important. That is, of course, why people say, what's the value you put on yourself? That's what people will take. If you get up in the morning, get up and go out and your hair all, you do one of them swoosh, swoosh. You know how you always do? When you don't feel like swoosh, and it kind of mix up the hair. I don't want to step on no corns, you know what I mean? But you know that you do that swoosh, swoosh. And you do that cowboy, you just take that water and do woo! woo, and that's it. You know what I mean? You're a cowboy. It's no problem. You comfortable, you happy, but how people see you, that's the problem. So in this business, when you are trying to judge what is the risk for your company of accepting a relationship with somebody who is just walking through the door, who you don't know, who hasn't been recommended to you by an existing customer or anything like that, and who's depositing cash which has no record, then you have to go by the profile. Is this the sort of person who you think should normally have $10,000? Report going again. Is this the kind of person who you think normally would have that kind of money to carry around? It's a judgment call. And that's why compliance is not tick the box, tick the box, tick the box. You have to think in this business. Like I said, years ago, I would have Americans come into the bank with a briefcase full of $50,000, $100,000. And there was no problem. We accept it. We not only accept it, we charge them 1% to count it. Just to count it before we put it in the account, we charge you 1% of the amount of money you're depositing. But today, where you have to report amounts over a certain amount, 10,000 in the States, where people are saying cash is high risk, you know, it's a problem. I went in the bank the other day with a check, not from a person, from a enterprise. Me? Touch that hands? No, not me. Anything I touch is break down. She know about it. Me and computers ain't friends. Thanks, thank you there. We got a computer assistant right here, so it's no problem. It froze in it. Okay. Okay. So we all right. She can take care of you anytime you pop off.
Thank you.
You're welcome. Yeah, me and computers, we ain't too friendly. I have a bad record with women and computers. What was I talking about? I lost that. You just lost me. What were we talking about? Oh yeah. First impressions when you are making a judgment in compliance. And see, the problem is people have figured out, let's say, oh, I was telling you something about my check, right? I walk into the bank with this check from a company, a business, and they tell me I can't deposit the check. I said, what do you mean I can't deposit? I know you don't take cash. Okay, but checks, you take the check and then you put a hold on it until it clears. What's the problem? They said, no, you have to take it back. That is how serious it has come. People not taking no chances no more. So even with a check, which I thought a business and so on, there was a problem. I carried back, and then within half an hour they say, yeah, go ahead, it's straight now. And I still don't know what is the reason. But people have decided it is easier to say no, and then later, if you have to apologize to the customer, say I'm sorry and so forth, and we're happy to take it now, that's better than to take it and find out you have a problem. It's better to say no first and then check it out and then say, okay, yes. Than to just take it and then afterwards you say, oh, Jesus Christ, what I let myself into now. So people err on the side of prudence nowadays. I think you better sit over here. I think you better sit next to her. See, that's the problem. Once you start, you can't stop. That is the problem. Once you start, you can't stop. Okay.
I can't see you.
You can't see me?
No, sir.
Okay. I'm not good looking, man. Don't worry about it. Just listen to me. Once you hear the sound of my voice, you're all right. So that is our problem. Our problem is, do we ask the question, who's the beneficial owner? Do we let them sign something saying, I am the beneficial owner, no one else, and then we go with that? Because there's no physical document from the company's incorporation which says who the beneficial owners are. So you really have to rely on the walk-in person, and again, that has to do with the impression that they give. Are they trustworthy? Do you believe them? You make them sign a paper. There was a thing, I don't know if I mentioned in this class, or there was a lady who was convicted in Florida, old lady, who had, what's about, I don't know, 50, 60 bank accounts, different bank accounts. And she used to rent the bank accounts out to different people who wanted to make deposits, and then they would tell her where to send the money. But she was opening bank accounts and renting them out. So then one of the items that they added to bank account opening forms was a clause that said, all deposits to this account will be beneficially owned by me, the account holder, to stop people putting other person's money through their account. Now, I was in a bank. I worked in Turks and Caicos for 7 years. I was in charge of the Financial Services Commission there. We regulated the banks, insurance companies, everybody, money transmission, everybody. And I was in this bank one day, and this Bahamian fellow walked in. Now, you know, when you know Bahamians in Bahamas, that's one thing. But when you meet Bahamians overseas, you got to be careful. They're tricky people. So anyway, he came up to me and he said he's trying to send some money to his son in the States. I said, well, it shouldn't be no problem. They could send it for him. He said, no. They said they can't send it. I said, why? He said, well, I don't have an account here. I said, you don't have an account here? He said, no. This ain't my bank. I said, well, why don't you go to your bank? He said, man, that's too far, man. He said, why you don't let me put the money in your account and then you send it to my son? And you know how you just get caught in these things? You want people to think you're a nice person. You know you're not a nice person, but you want people to think you're a nice person. So I said, all right, it's only $300 or something. He deposited in my account. I sent it to his son. Next thing I know, I get served with a subpoena from the bank to come to court. I said, well, what happened? Well, apparently we send the money to his son. His son say he didn't get it. The bank say the son got it. Now they're saying it's a fraud. I said, Jesus Christ. Eventually, it turned out that the money did not go to the son. It was returned for some reason from the States. And he had to send it again through another bank. But I'm saying, I got myself mixed up in this, just innocent. You know, just innocent trying to help another Bahamian. So now when I see Bahamians, when I overseas, I turn my head. I don't know you. I'm from Dominican Republic. I don't know habla inglés. I'm not fooling with y'all no more. Y'all don't even get me in trouble. So that is the beneficial owner problem. You can only ask and let them sign a paper saying, yes, I'm the beneficial owner. Question? No? Okay. Right. Partnerships. With partnerships, what you're dealing with is identification for each individual partner. So if there are 5 partners or 10 partners, you have to get documentation like you would for any individual for each of the partners. Now, again, I don't know why this is, because I figure if you're born Kevin Higgins, you can stay Kevin Higgins. But they have introduced something called continuing verification, which says that you should update your documentation every 5 years or so. So I got a call from the bank saying, Mr. Higgins, we need to update your documentation. We checked the files, we're doing a review, and we see that yours is very old, and so you need to come in with your current driver's license. So I said, well, you think my name changed or something? You think I was born again or something? What's the problem? They said, no, sir, you have to bring in your... So I bring in my driver's license. Then they say, well, we need verification on where you live. This is the utility bill. So I had to give them a utility bill. So there is not just identification, but there's continuing verification. Usually, most institutions say every 5 years. You should update and review the file, make sure you have the full documentation. And that is partly because, as we've said, the rules and the standards change. Because when I opened my account, however many years ago, nobody asked me for no utility bill. But nowadays, that's standard. So there's a need to, on a regular basis, review files and ensure that you have the current requirements for documentation, whether it's an individual or it is a company. Now, when can you destroy documentation? 5 years, 7 years, from when? When does the clock start? From the closure of the account or the relationship with the customer, right? 5 years is required under anti-money laundering. 7 years is the international standard because of civil action that can be taken against the institution. So again, your manual should say whether it's 5 or 7, and somebody should be responsible for signing off. The records manager we talked about. These files can be destroyed because the customer closed the relationship in this state, and it is now 5 years or 7 years. So this again, like we're saying, rules, and you need to have a manual which is comprehensive that tells you what to do in all of these situations. You need to have different people who are responsible for different aspects. You need to have annual review and training because you can't remember all this stuff. There's no way you can remember all it. So you need to have that annual update, that annual review, so you are reminded of what you need to do, as well as you're advised of any amendments to the law or any changes and so on. And especially because people find new ways to get around the rules. So you need to be aware of the most recent, what are called typologies. Which is the methods of circumventing the law. Because that changes all the time. Okay, I wanted to talk about the most recent amendments. Where is the most recent amendments? I can't find it. I wanted to talk about something about amendments. I got so much paper, stuff is starting to get lost. Oh, come on now. Right, here we go, right at the front. Okay, in 2008, the Bahamian laws were updated and some additional issues were addressed. The first thing that was addressed is what is called the occasional transaction. OCC? Occasional, OCCAS. Okay, this is where a person doesn't have an account with you, but they come in and they want to do something, and it's a one-off. The English call it a one-off. All right, they're not a regular customer. They just come in on a particular day to do one thing, and you'll probably never see them again. So there are rules about occasional transactions. And the rules say, even if it's an occasional transaction, you still must have the ID. Okay, you might not have the utility bill and all them kind of things, but you must always have the ID. And the idea is so that there's a paper trail to follow the transaction. So the rules on occasional transactions were updated in the 2008. The second thing they did in 2008 was they included accountants and attorneys as financial institutions. In your business, you deal with all kinds of people, civil servants, construction workers, and so on. But one of the areas that is considered high risk is accounts for accountants and attorneys. Because accountants and attorneys, part of their business is to handle other people's money. That's part of their business. They have client accounts, which means they have money that is not theirs, it's held on behalf of their clients. So when an accountant and an attorney comes in to do business with you, you have to be very clear whether it is their personal funds or whether they're acting on behalf of a client. So accountants, attorneys are considered high risk. The other high risk people, of course, are, who are these boys? Who? Perry, Gladstone, Christie, and that. Political exposed persons. Perry, Gladstone, Christie, and that. That's who that is. All them politicians. They're considered high risk as well. So anytime you get a politician, you need to be careful. And nowadays, they go further. They say politician or public servant. So a fellow who's the governor of the central bank or the financial secretary or the permanent secretary for the Ministry of Works would be considered politically exposed as well. So be careful. If they look like when they start with, do you know who I am? That's when you need to be careful. Do you know who I am? Watch that set. Dangerous people. The next thing is auditors. Under the amendments to the law, auditors are given a specific responsibility to report suspicious transactions. So when your auditors come in to do your audit, if they see a transaction that's suspicious, that you did not report, they can report it. And of course, people are going to say, well, why didn't you report it? If the auditors think it's suspicious, how come you didn't think it was suspicious? So now you have external auditors who come in to do financial auditing, but who also are responsible for reporting on any AML issues that might arise. So there's somebody checking on you that you mightn't even know is checking on you. And let me tell you again, if you have an external auditor come in and they look at something and say, why you didn't report that? And you say, well, I didn't think because so and so and so. And they say, well, no, I think you should have reported that. Leave right away, fill out the form, and report it. If you don't mind, it's late, report it. Because that auditor will report it. And you know how people will think? People will think you're covering up. So don't argue with them. You report it, and if anybody, the manager, somebody says, why did you report it? You said the auditor identified it as a high-risk transaction. You have a problem, talk with the auditor. It's not me. The auditor identified it. Protect yourself at all times. Disclosure is protection. Next one. Under the amendments in 2008, the financial intelligence guidelines were made enforceable. That means guidelines, you say guidelines, that means I could follow them, they provide guidance, but they're not laws. But they made them enforceable. It means if there is something in the guidelines that you have not done, if you go to court, the court can say, we judge you guilty because you didn't follow the guidelines. The guidelines are enforceable. So, you can check but I believe that the FIU guidelines apply to gaming industry. I don't know if the gaming board has issued separate guidelines for anti-money laundering. Anybody know? No, not as yet. Because the financial intelligence guidelines were made enforceable for all. So you say, well, I don't report to FIU, I report to the gaming board. But those guidelines have become the standard. So if you're going to do compliance, get a copy of the FIU guidelines and make sure that you're meeting those standards. Because again, the courts will go by what's in those standards, even though they mightn't say that. They might say, well, the gaming board and so on and this, but they're going to say they are national standards and bam, 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 but that's the standards they're going by. Right, okay, that's the last thing I want to say. All right, so I'm going to stop there. Any questions? No?
Just to say which law this was that was amended in 2008?
This is the Financial Transactions Reporting Amendment Act. Financial Transactions Reporting Amendment Act, 2008. That's what I keep saying. They keep moving the goalposts. They keep raising the bar. They keep changing the standards. What is good today ain't gonna be good next year, because they'll find somebody else has gone through it, around it, a different way, and they'll put a block. This is a tricky area that is constantly changing. Any questions? No? Everybody's okay? Yes, ma'am. Huh? Typologies refers to new methods of avoiding the laws on money laundering, new ways of getting around money laundering. And there are always new ways being developed. I told you the story when I was in one of the money transfer places, and these fellas came in, and I see them share up the money between the three of them, and then each one of them went and tried to send money to the same person, and the people tell them, no, you can't do it like that. I don't know if they were trying to keep it under the limit, because that was when I think $1,000 per person was the limit. I don't know if it's that or there was something else, but anything funny, they block them out. Lady came and said she has two passports. She has a Bahamian passport and an American passport. The lady said, there's no problem. But the problem was, the Bahamian passport was in one name, and the American passport was in another name. And she said her mother registered in the Bahamas in one name, and her father registered in the States in another name. Now that might be true, but ain't nobody taking that chance no more. Better you would keep your mouth shut and say, I got a Bahamian passport, and finish with that. Something going on. You know, if I'm an old man, I'm fat, I wear glasses. If a beautiful woman come up to me and say, hello, Mr. Higgins, I run like hell, because I know it's a setup. And a beautiful woman want me. All right, see you next week. Bye, Freeport. Take care. Huh? She in love?
She probably ready to go.
No, she right there staring at me. Then who is this man talking this fool that I pay all this money for? Take care, man. Yeah, next week. Okay.
I packed. I was supposed to pack down in the back.
You know,
I'm going now. That's just
Everybody's name is on the sheet, right?
We going through the
So he was gonna give us some.
We did, ask Mr. Pratt.
Mr. Prado?
Yeah,
Oh, okay.
because all the copies that were here gone.
Oh, okay.
Hold on, I still confused.
So y'all gotta get, y'all come on, though. Don't knock it.
You can get out.
Remember, the exam, your only testimony is